Nagbabalik po muli ang inyong lingkod at nagbabalita ng mga balitang dapat nating malaman dito sa ating bansa. Ito ang Balitang Pambansa. Ating ngang matutunghayan sa channel nito kung ano ang nangyayari sa loob ng ating gobyerno at syempre tumutulong na rin sa ating mga mamamayan na malaman ang katotohanan dahil mayroon tayong karapatan na malaman ang tunay na nangyayari sa ating bansa. Ngunit bago natin panoorin ang balita, huwag niyo pong kakalimutan na mag-subscribe sa ating channel at pindutin ang notification bell para lagi kang maging updated sa ating mga bagong videos na ina-upload araw-araw. At sa ating mga solid viewers naman dyan ay maraming salamat naman po sa walang sawang pagsuporta. At syempre, huwag din pong kakalimutang mag-iwan ng like at i-share ang ating mga videos. At kung mayroon ka naman pang opinion, ang ating comment section ay bukas para sa inyong mga hinaing. Ito na nga mga kaibigan, ating panoorin ang buong video. Salamat po muli and God bless!
Secretary Gibo at si Secretary Anyo yung sinasabing mastermind nung pag-aresto po kay dating Pangulong Rodrigo Duterte. Sino po yung nag-utos sa PNP, especially kay General Torre, para po isagawa yung pag-aresto sa dating Pangulo? Yes.
Itatanong ko lang po, sino po ba sino po yung nagsabi ng word na mastermind?
Nako.
Yun po yung binabanggit.
Ang hirap po dito kay Claire Castro, siya tinatanong, tapos ibabalik niya, siya naman ang magtatanong.
Sa Senate hearing kahapon. So kung hindi po mastermind,
tanong ko lang po kasi para
sino po yung nag-utos? Ayun na po yung word.
We have to correct that. May mastermind ba tayo na dinig?
Anak ng toko, ang labo naman ho nun. Pagka merong nag-utos, consider na yon sila yung mastermind. Ito, inaano nyo lang, kumbaga pinapaikot-ikot nyo lang di ba? Kapag ikaw ang nag-utos, ikaw ang mastermind. Automatic na ho yun. Hindi, ano bang kaibahan nung nag-utos tsaka mastermind? Anak ng toko, alangan naman yung nag-utos, hindi yun ang mastermind. Ito talaga, sagutin nyo na lang ho kasi ng diretso ang tanong nitong si Ma'am Eden Santos. Kung sino ba yung mastermind? Idinideny na hindi itong si John Vic Remulla. Idinideny nitong hindi si Boying Remulla. Hindi raw yan si Gibo Chodoro. Hindi daw si Marcos Jr. Ngayon, sino ang mastermind? Diba? Hindi ho matatapos yung mga katanungan na yan na Yusek Claire Castro. Habang nandiyan ka sa posisyon na yan, paulit-ulit tayo kasi hanggat hindi nabibigyan ng hustisya, yung ginawa ng administrasyon na yan kay dating Pangulong Rodrigo Duterte, hindi ho matatapos ang mga katanungan na yan ng ating mga kababayan.
Kasi for us, it's medyo negative yung dating. Parang
Sino po
mafia
yung
dating.
nag-utos kung hindi po master?
Sa'yo na mismo galing yung salitang mafia. Ano bang nangyayari ngayon dito sa administrasyon na to? Puro kabudulan. Diba? Hindi ho ba galawang mafia yung tipong bababa ka sa eroplano, ngayon naarestuhin ka, dapat sana idadala ka sa competent judicial authority. Hindi ho kayo dinala doon. Bagkos nagsiga-sigaan si Torre, hindi ho ba gawain ng isang yung tipong doon sa salitang ginamit nitong si Claire Castro. Di ba gawain ng parang mga mga siga, no? Yung tipong hindi na ho nila sinusunod ang batas. Di ba? Hindi na ho nila sinusunod ang batas. Galing na ho mismo yung salita dito kay Claire Castro. Yun ho bang ginawa ng administrasyon nitong si Marcos Jr. dito kay dating Pangulong Rodrigo Duterte? Hindi ho ba gawain ng isang ng isang parang mga gawaing tulisan, ika nga, di ba? Kasi mamaya ho, papanuurin ho natin ang mga punto de vista nitong si former Associate Justice Adolfo Ascuna na kung saan, base doon sa kanyang mga ilalatag na argumento dito, talagang merong paglabag na ginawa ang administrasyon ni Marcos Jr. Tuloy natin.
Unang-una po, nagpapasalamat po tayo na nagkaroon po ng Senate hearing patungkol dito. Mas naliwanagan ang tao, ang taong bayan, kung ano ba ang nangyari. Napaliwanag po kung ano yung batas, at kung ano lang yung ginawang batas. Kaya maraming salamat sa pagkakaroon po ng Senate hearing na ito. Kung sino po ang nag-utos, wala po tayong personal knowledge dyan. Kung ano po ang napag-usapan, wala pa rin po tayong personal knowledge dyan. Kung naganap na po ang dapat na naganap, Yan po ay naaayon naman po sa batas.
So, ibig sabihin po, sariling decision po ni General Torre, yung lahat ng nangyaring pag-aresto, pagsundo sa NAIA, sa dating Pangulo at sa kanilang grupo.
Wala po akong sinabing ganyan. Ang sinabi
Tinatanong kung sino mastermind. Sige, hindi na mastermind yung term na gagamitin natin. Sino ang nag-utos dito kay Torre? Ano kasi kayo gumawa ng kabalbalan ng administrasyon noong natitiklo na sila na kumbaga nahahalata na sila, bigla ho silang kabyo patras. Nagtuturuan ho sila. Kasi wala naman talagang pagpaplano. Ngayon ho pala mga kababayan, meron ho pala talagang operasyon na kaugnay dyan sa pagkakaaresto na yan. Itong si dating Pangulong Rodrigo Duterte. January. Nitong taon na to talagang inumpisa na yung ano na yan, yung operation, kung ano man yung tawag dyan sa operation nila na yan. Talaga hong pinagpaplanuhan nila. Kumbaga yung pag-alis ni Tatay Digong, paglapag sa airport, makukurdon nga naman nila yung airport kasi hindi ho basta-basta kagaya dyan sa Davao. Paano mo gagawin sa Davao yun? 'Di ba? Kukuyugin si doon. Si Pisot, 'di ba? Hindi ho makakapalag sa yun sa Davao. Hindi ho pwede yung kayabangan niya niya doon, yung dadalhin niya yung mga kayabangan doon sa doon sa Davao. Yung pagsisiga-sigaan niya, gustong makita nitong si VP Sara ang kanyang ama, hindi niya papakita. Nako.
Pulang naman natin, wala po tayong personal knowledge kung ano po ang napag-usapan nila.
Okay, ICC has no jurisdiction over the state but has jurisdiction over individuals according to Justice Secretary Remulla. Can you elaborate po itong binanggit niya ito or can you explain it para po mas maliwanagan ng taong bayan?
Kasama natin po mamaya si Atty. Joel Butuyan at siya po ang mag-i-explain patungkol po dyan.
Thank you.
Hindi na, huwag na nating ipakinggan yung si Butuyan. Pakinggan natin itong si former Supreme Court Associate Justice Adolfo Ascuna. Ito pakinggan ho natin, ito dati sa kumbaga yung grasp nito o yung kung paano niya intindihin yung batas at ang kanyang kaalaman sa batas, hindi uubra yung magsasalita dyan sa Malacanang press corp. Dito tayo kay Adolfo Ascuna. Itong si Justice Adolfo Ascuna. Malupit ito mga kababayan. Panoorin natin.
It really is the issue that is facing the country today is the arrest warrant issued by the International Criminal Court against former President Rodrigo Duterte, valid and legal, and is its execution by Philippine authorities equally valid and legal, and its subsequent transfer or surrender of Mr. Duterte to the ICC, is it also valid and legal? These are the questions we'll discuss tonight.
So we'll start first with the warrant of arrest issued by the ICC.
Yes.
Do you see any infirmities? What is your legal analysis of the warrant itself?
Okay, the warrant of arrest issued by the ICC was issued pursuant to its jurisdiction over crimes against humanity committed in the Philippines during the period when we were parties to the Statute of Rome. That is from 1 November 1911 to 16 March 2016. Yun po ang what we call the relevant period na kung saan party tayo sa Statute of Rome for crimes. Crimes against humanity, genocide, war crimes, and aggression. In the case of former President Duterte, it is crimes against humanity na charge sa kanya. Ngayon, nag-issue ngayon ng ICC ng warrant of arrest pursuant to an investigation. Marami pong katanungan dyan. Considering na nag-withdraw na tayo, makaka-issue pa ba ng warrant of arrest ang ICC? The answer is yes, if it falls under Article 127, Paragraph 2 of the Statute of Rome, where it says that even after withdrawal, the withdrawing state continues to be obliged to cooperate with the ICC in relation to matters already under consideration by the court before withdrawal. That is the issue now, whether or not the Duterte case or the Philippine situation was already under consideration of the court before we withdrew.
And well, Attorney Mike and Justice Adolf, this is something that as lawyers we can also be clarified on, because a lot of us don't get educated on international law and the rules in the ICC. What is being a matter under consideration to fall under that provision of the Rome Statute? Because there was an ICC prosecutor that supposedly began investigation prior to our withdrawal from the ICC.
That was Bitsud?
Yes.
The
one who was before Khan.
Yeah, but is that consideration already? Does that fall as a consideration?
Very good point, Attorney, because Patu Bensouda, the former ICC prosecutor, announced that as of February 8, 2018, that is before withdrawal, the preliminary examination of the Philippine situation began. Question: is the examination by the ICC prosecutor a matter under consideration by the court? I researched on this and I found out that the court has 4 principal organs: the presidencies, 1 president, 2 vice presidents; the judicial divisions, pre-trial chamber, trial chamber, appeals chamber; the prosecutor and the registrar. In other words, the prosecutor is part and parcel of the court. So whatever is under consideration by the prosecutor is under consideration by the court. So I believe it falls under our residual obligation because it was already under consideration by the court as of 8 February 2018.
But Justice, there's also another argument which says it was beyond the 2 years prescriptive period. Therefore, hindi na pwede kasi lumampas na nga eh. Kasi dapat after the February 8,
Yung raise na punto nitong si Attorney Salvador Panelo. Kumbaga naglaps na.
Yes.
they should have already filed within the 2 years. Unfortunately, it went beyond 2 years. So they're saying now that it's not covered. What is your position on that?
Yes, Attorney Mike, that is true. There is also another angle that the preliminary investigation, aside from the preliminary examination, there's such a thing as preliminary investigation, a more formal investigation, must be commenced after withdrawal within 2 years.
Yes.
Okay.
In our
Was it
case,
done in this case?
it was done September 8, 2021, more than 2 years.
More than 2 years.
From 2016 or 17. So, anong validity nito? Questionable yan. Again, we can consider it in relation to Article 127, Paragraph 2, na there is a continuing jurisdiction over matters already under consideration. So, in case of an earlier examination, maybe it can support a subsequent investigation as it is a continuation of something already begun before withdrawal.
And would this be part of matters taken up at the confirmation hearing?
They call it Philippine situation. So that is part and parcel, the Philippine situation already under consideration by the court.
Therefore, ICC has
By the
jurisdiction,
ICC, as
has
an
acquired.
institution.
Yes,
Yes.
as an institution.
Okay, but going now to the way that the ICC warrant of arrest was enforced in the Philippines, what is your analysis on that, Justice Adolf?
Okay, there is a peculiar procedure for enforcement.
Eto na ho, oy, Boying Remulla. John Vic Remulla, at para dito kay Marcos Jr., makinig ho kayo dito. Kasi dating associate justice to, ibig sabihin ano ho ito, pagdating sa batas ang pinag-uusapan, talagang napakadalubhasa ho nitong si Justice Ascuna.
Warrants of arrest. Because the ICC does not have police agents. It relies on the state parties to execute its warrants of arrest. And it does this through the Interpol, the organization of police agencies around the world, to which we are also a party by another treaty that's created the Interpol. And it sends what they call the red notices or red flags, sealed communications to Interpol agencies, which may contain its warrant of arrest. This is what happened here. Its warrant of arrest was served through the Interpol, and the Interpol, the Philippine agency of the Interpol, was the one that opened the letter, and it contained the warrant of arrest, and it passed it on to our Philippine police agencies, who decided to execute it in accordance with what they felt our obligations under the treaty.
Okay, but something that is not clear to me is why the Philippine government statements, including during the Senate hearing on the arrest of former President Duterte, remains to be that we are not part of the ICC, we no longer recognize their jurisdiction, but the arrest was carried out in cooperation with the Interpol. Why cannot we just state that it was pursuant to our residual obligation under the ICC pursuant to the Rome Statute?
Yes, the arrest, the combination, the execution of the arrest warrant is based on a combination of legal factors. One is the Interpol agreement, the other is the Statute of Rome, the continuing obligation under 127 to cooperate. So you combine these two, it results in the execution of the warrant of arrest.
Regardless, let us assume, for the sake of argument, that it was not a valid arrest, that it was not even a valid warrant, and it was not a valid enforcement of the warrant.
Yes.
Let us assume, for the sake of argument. But now that he is already within the jurisdiction of the ICC in The Hague, which, by the way, Attorney Karen was just there, and we'll talk more about that later on, will that in any way affect his standing in the ICC? Or let me rephrase that. Will that make the ICC judges say, look, the way he was arrested and the way the warrant was issued are questionable. So therefore, I think we cannot touch or rule on this case.
Yeah, I'm curious about that as well, because in the Philippines, we do have that doctrine, fruit of the poisonous tree, meaning if you execute a warrant that was obtained illegally, or if the warrant has any infirmities, or even the way you execute it, if you violate constitutional rights, then it does affect the ability of the court to try an accused.
Yes, that is the doctrine in domestic courts, but in international courts, they follow the doctrine that's called male captus bene detentus. Ang ibig sabihin yan, illegal arrest but legal detention. The international court is charged with trying the most serious offenses in international law. Therefore, it will balance irregularities in the arrest of a person brought to its jurisdiction with the need to impose or to prosecute violations of most serious offenses. And if the balance is in favor of prosecution, they will disregard irregularities in the arrest as long as the person is within their jurisdiction and turn over to their jurisdiction. They can try and prosecute the person.
Okay,
Alam mo, partner, ano yan eh, parang, di ba, nangyari yan kay Adolf Eichmann.
when he was abducted and drugged?
He was abducted by the Mossad, if I recall correctly, it was in Latin America, and was brought in to Israel to face trial in Israel, in the Nuremberg trials, for example, as well. And at that time, the court said, no, we don't care how you brought him here, the fact that he's here already, and he has to face the consequences of what he has done, crimes against humanity, and all that. So therefore, the trial continued.
Was that under the Rome Statute as well?
Not yet.
Attorney
It
Mike?
was not. In fact, the Nuremberg trials, as well as the Tokyo trials, were the precedents, so to speak.
So would you
that
say
they came up
the-
with the Rome Statute and then the creation of the ICC, because there was a recognition that some authoritarians or demagogues or some leaders would commit such heinous crimes against humanity, would murder, kill millions of people, and they may be able to go scot-free because in the place where they are, the justice system will definitely not find them guilty or can even apprehend them. So there was a recognition that the global world decided that in order to discourage future leaders from doing such things and to make sure that whoever is found guilty would have to pay the consequences and set an example that it should not ever happen again. Thus, the creation of the ICC under the Rome Statute, which was, I believe, in 1960 or 1961.
So that event also influenced what was drafted eventually as the Rome Statute.
Yes.
Is that correct?
Probably,
Justice?
yes.
Justice Adolf, just to take a step back, when it comes to the enforcement of an ICC warrant of arrest, what would be the proper procedure? In this case, during the arrest of former President Rodrigo Duterte,
Yes.
were the provisions of the Rome Statute followed?
I believe they were not, because under the Rome Statute, Article 59 requires that after serving the warrant of arrest, the custodial state, in this case the Philippines, should bring the person arrested to a local court,
Nako.
which will then determine whether or not he or she is the person named in the warrant of arrest, whether or not the person arrested was informed of the nature of the charges against him or her, and whether or not his fundamental rights were respected. These are the three issues that a local court must determine before the arrest can culminate in a surrender to the court. That is, however, according to other experts, that is no longer applicable because we are no longer parties to the Treaty of Rome. So the Article 59 procedure is no longer a requirement, which is probably why in the March 17th hearing in the ICC by the pretrial chamber, I observed that the pretrial chamber did exactly what a local court should have done under Article 59.
Which is what?
Which
to
is
identify
to make
the
sure
arrest.
that the person arrested is the one named in the warrant, and that the person arrested was informed of charges against him.
In other words,
Okay.
there's due
Yeah.
sort
Yes.
Well,
due process.
unidentified.
Yeah, in a sense, it was
Yes.
a kind of due process under international law,
Yes.
if you
Nako.
follow that provision of 51.
Yes.
But the counter argument against that is the fact
na.
that we are
Eto na ho.
we enacted
Ito na ho talaga yung portion na para kay Boying Remulla. Ito na.
a statute 9158 and specifically Section 17, which allows us or allows government, upon making their own determination, that perhaps it is better that the accused in a particular case can be now surrendered to a international organization or to even a country.
Yeah,
There-
I remember that provision is either extradition
Yes.
or voluntary surrender.
Surrender.
So in this case, what happened was surrender.
surrender. So
But when you
is there
surrender,
a clash? Is there a clash there?
Yeah,
or-
I'm curious. So first, just to go back, with the Rome Statute, if we had withdrawn but an ICC warrant of arrest is being served pursuant to the Rome Statute, then I'm a bit confused with the contention that the provisions of the Rome Statute will no longer apply in terms of bringing an accused before a competent judicial authority.
Yes, that is true. The Rome Statute will only partially apply to the extent that our residual obligation to cooperate is still valid. But the rest of the provisions will no longer be applicable because we are no longer parties to the Rome Statute. So the warrant of arrest, its validity, and our obligation to honor it continues because of 127. But 59 no longer applies.
Is that
Because-
do you agree with that view?
No, my view is that you cannot be selective. If you want to
Naku
apply
po.
the statute of Rome because you are still obliged, then you apply the whole thing.
Yeah.
Naku,
So to me,
kung in-apply natin yan, dapat apply natin lahat. Hindi ka pwede maging selective, Boying Remulla. Yung tipo, at saka dyan, para dito kay Claire Castro. Hoy, Claire Castro, hindi nyo pwedeng sabihin na yung isang provision, yung pag-serve ng warrant, yung merong nalabag, itong si dating Pangulong Rodrigo Duterte, dyan sa isang provision ng ICC. Ngayon, yung isa na yon susundin nyo, tapos yung mga magpuprotekta para sa kanyang karapatan, hindi nyo papansinin, hindi naman huwata patas yun. Dapat dito, kung yung kanyang nalabag, pananagutin siya base dun sa provision ng ICC, pati yung mga poprotekta sa kanyang mga karapatan, diyan sa Rome Statute, dapat ginalang din ho dapat ng administrasyon ni Marcos Jr. Selective ho kasi sila Dapat doon lang sa nalabag. Ngayon yung mga karapatan niya nitong si Tatay Digong doon sa treaty na yon, hindi na ho valid, kumbaga wala nang jurisdiction. Yung meron lang jurisdiction doon sa mga na-violate ni Tatay Digong. Pero pagdating doon sa karapatan niya, bilang isang Pilipino, bilang isang nasasakdal sa ICC, wala na hong jurisdiction ng ating bansa doon. Di ba? Selective ho sila. Yun ang tinutukoy nitong si Associate Justice Ascuna.
there is a violation. But as I said, the ICC doesn't care if there is a violation as long as it is balanced against the need to prosecute. So they will disregard that. In fact, they cured it already under the rules.
Yeah.
They have the rules also.
Yeah.
More than 127 sections. Under the rules, they can cure it.
Oh, there is a
Yeah,
curing.
they're
Okay,
allowed
this is
to cure
super
it.
helpful because I haven't read
That's
They're
what
the
they do.
rules of the ICC.
Yeah,
So
they have
they have a
rules of
way to
court.
cure. So if there's a violation of due process in the either custodial state
Yeah.
or the home state of the accused, the ICC court can cure any
Yes, they can
of
cure.
those violations.
They can cure the violation. That's why they said, "Are you the one name?" And of course says yes. Were you informed? Yes.
yes.
Session adjourned. Yun lang dalawa. Yun ang dapat dito ginawa
Dapat nasa Pilipinas.
dapat.
Okay.
Just going back to touch on another topic, but related to this.
Galing itong si
The habeas corpus case is now filed.
That's exactly what I was going to ask about,
Diba?
which is perfect
Which
because
is-
you have a
yeah.
justice of the Supreme Court.
It's pending in the Supreme Court. There's a habeas corpus filed by the children of President Duterte.
Yes.
There's an argument that it is no longer, it's already moot because he is already there in The Hague. Therefore, what's the point for a writ of habeas corpus? And there's also an argument saying that, number two, well, writ of habeas corpus only applies if a person is illegally taken away. And you have to show to the court why he was taken away and show his body to the court. Now, in this case, they're saying, but he was surrendered validly pursuant to an agreement with the Interpol. And then again, he's now in the ICC. So what is your view on that as far as the habeas corpus cases are concerned?
Okay. First of all, it's not muted, this habeas corpus case, simply because we can no longer return the former president because he's already in the hands of the ICC. So habeas corpus will not lie because it's supposed to be to return the body.
Yes.
But there's also another dimension of habeas corpus, which is the legality of the surrender. And that's not muted. The court can rule on that. On the legality, my opinion is that Section 17 of Republic Act 9851, which provides that in case someone already being investigated by international tribunal, the Philippines may surrender such person. But the last sentence says, pursuant to treaty obligations.
Yes. Yes.
But in this case, since we withdrew, are you saying that the
Correct.
basis could still be
Yeah.
the Rome Statute? What is the analysis
That's
here?
it. So, is there still a treaty or not? If there is no treaty, then you cannot surrender. because the surrender under Section 17 must be pursuant to treaty obligation.